Well, I'm chairing today's session. Hello again to those of you who joined our first webinar on the 21st of September, and welcome to those of you who are joining us for the first time. Nice to, well, we can't see you, at least we'll see your names. For those of you who don't know me, I'm Peter Morris. I was managing partner of Burgess Salmon for 8 years, and I'm here today in my capacity as chair of the Bristol Legal Sector Community Engagement Group. The Bristol Trustee Group, which is organising this series of webinars, is a subgroup of both the CE Group and also Bristol Pro Bono, and Victoria's going to say something about that in a minute. And we're kindly hosted today by Bristol Law Society. Today's session is all about key roles and responsibilities of trustees. We've got two speakers. The first will be Emma-Jane Dalley, who's a partner and charity expert with BWV, which I know as Veal Wasper Vizards. Emma-Jane will be followed by Caroline Turner-Inskip, who is a real estate lawyer, but who's here today really in her capacity as a trustee to speak about the practical aspects of trusteeships. So thank you to you both. Just a couple of housekeeping issues before we get started. The first, as Helen's mentioned, is that this session is being recorded and will be made available afterwards so that you can view it, or you can view it again, others can view it, or you can view it again if you want to, and that will be sent out together with Emma-Jane's slides. Can I ask you to save your questions for the discussion so that both Emma-Jane and Caroline have a sort of clear run at their presentations. However, because the way we do Q&As here is to submit them, the questions in writing. If you look at the bottom of your screen, you'll see on the right-hand side a Q&A tab, which is for the purpose of submitting questions. So please do start submitting questions as soon as you want to. I know that both Emma-Jane and Caroline would like this to be as interactive as possible. So Caroline in particular will be trying to pick out questions which she can deal with when it comes to her slot. We think that the two presentations will take around about half an hour, give or take. Emma-Jane's got quite a number of slides to get through. All look interesting. I'm looking forward to hearing this myself because I'm a trustee and I probably should know more about it. I will, however, endeavour to make sure we're finished on or before 2 o'clock, as I know you're all very busy people. So before we ask Emma-Jane to start her presentation, can I just ask Victoria, who chairs Bristol Pro Bono, to say a few words about how this training initiative of trustees links in with the work of her group. So Victoria, over to you. Thanks.
Absolutely. Thank you very much, Peter. As you mentioned, I am chair of the Bristol Pro Bono Group, and I am also Pro Bono manager for Simmons Simmons. So that basically means that my mandate is to increase engagement in pro bono across Simmons's offices worldwide. So this is my full-time job. And prior to that, I was working full-time as commercial litigator. The Bristol Pro Bono Group has been going for about 18 months now, and our members comprise of representatives from law firms, barristers' chambers, universities, and also local entities such as the Bristol Law Centre, who are working to provide pro bono support to those who need it most in Bristol, in and around Bristol. So we liaise very closely with the Community Engagement Group, which Peter is involved with, and we're absolutely delighted to be part of the Bristol Trustee Group, where we can lend our legal expertise of our members to hopefully assist trustees across the city and the southwest and further afield, if you're joining us from elsewhere, to top up perhaps the knowledge that they need in order to execute their roles in a competent manner, shall I say. So today we're delighted to be joined by Emma-Jane and Caroline, who's a colleague of mine. And I'm very interested to learn the basics of the roles and duties of trustees. I'm not a trustee, but I'm certainly considering becoming one. So Emma-Jane, over to you.
Thanks, Caroline. Sorry, just taking myself off mute there. So, hi everybody. As Caroline said, my name is Emma-Jane Dalley. I'm a partner in the charities team at BWV, which means that I exclusively advise charities on all aspects of their legal issues, but a lot of that comes down to governance issues that we're going to be covering today. And just trying to move the slides along, which I'm doing with very little success at the moment. Okay. So just to cover, just say what I'm trying to aim to cover today is to talk a little bit about the legal and regulatory framework, just to give this all a little bit of background and perspective. Then looking more at the role of charity trustees and the potential liabilities that you could take on in becoming a trustee, not to scare you away from doing it because it's a fantastic role to do, before looking at the key duties and a couple of governance areas. It's going to be a bit of a whistle-stop tour, and much of this might be familiar to you as existing trustees or from your own roles, but hopefully there'll be something to pick up for everybody. I should say that I have also been on the other side of the fence, although I've got two very young children at the moment, so I'm not currently a trustee, but I have been as vice chair of trustees of a charity for young people with learning disabilities. I've been a governor of a FE college and a governor of an independent school, so I do have some knowledge on the other side of the fence. Right, so if we get started, see if I can. I think the best place to start is with the legal framework and looking at the Charities Act 2011, which sets out the definition of what a charity is, and in particular the 13 purposes which are considered to be charitable. And many of those will be familiar to you. They range from the advancement of education to the advancement of human rights, health and saving of lives, animal welfare, and cultures and arts sector. And all charities must have as their charitable object something which fits in with those 13 charitable purposes, or one or more of those. And the charitable objects of a charity are really important because they set out what a charity is established to do. And we're going to look at that again in the context of your trustee duties a little later. And regardless of which charitable purpose a trust or charity is set up to do, it must advance public benefit. And the Charities Act 2011 is also the main source of legislation that is relevant to charities. And the majority of charities in England and Wales are required to register with the Charity Commission if they reach a particular threshold. Principally, that's having an income of more than £5,000 or being structured as a charitable incorporated organisation. And I'm guessing that the vast majority of people attending this seminar will be representing registered charities, but it is important to remember that there are some charities that are exempt in that they have what is known as another principal regulator other than the Charity Commission, such as universities, which are regulated by the Office for Students, and also academy trusts and community benefit societies, and they're known as exempt charities. And absolutely key to the legal framework for any charity is how it is established, and these can broadly be divided into what we term incorporated structures and unincorporated structures. This probably isn't a surprise to anybody, but principally incorporated charities will either be structured as companies, normally limited by guarantee, but very occasionally limited by shares. Charitable incorporated organisations known as CIOs, and those are a relatively new legal form set up only for charities, aimed to prevent the dual registration of charities at Companies House and the Charity Commission and the dual regulation that goes with that. There are also royal charter bodies and statutory corporations. And then the unincorporated charities are normally structured as trusts established by a trustee. They may be what I call a scheme charity in that they are regulated by a Charity Commission scheme. Or they may be an association, which typically has a separate membership in addition to its board of trustees. And its rules and regulations are normally set out in some form of constitution. The distinction between these types of charities is important because it has a number of impacts on things like how the assets of a charity are held. So an incorporated charity can hold assets in its own name, and it also has, it's a legal entity in its own right, so it holds assets in its own name, and it can enter into contracts on its own behalf and be sued and sue in its own name. An unincorporated body, of course, has no separate legal entity, and only its trustees can hold assets and enter into character contracts on its behalf. And clearly that has an administrative impact as trustees come and go from the charity over time. And perhaps, as you'll all be familiar, one of the greatest advantages of incorporated charities is that the vast majority of those have limited liability. And this means, of course, that if the assets of the charity are exceeded by its liabilities, then the trustees and members of that organisation will not be responsible for the shortfall. So if a large claim came into a charity and that claim was successful and exceeded the value of the assets, the members and trustees would be protected. But that is not necessarily the case for trustees of an unincorporated charity, where typically the trustees will be responsible, albeit there are ways in which they can seek to limit their liability. And of course, limited liability is not foolproof. There are situations in which trustees of an incorporated body can find themselves personally responsible. The obvious one there is, of course, under insolvency legislation, but also in areas such as health and safety and data protection. So looking a little at the regulatory framework, again, this is just a sort of whistle-stop tour. The Charity Commission is the principal regulator of registered charities, and it has a number of statutory functions. In practice, of course, its resources and ability to do things is limited by its resources and the number of people it has working for it. But typically it carries out its role by providing advice and guidance to charities. And its advice and guidance documents are particularly helpful and are normally a good starting point for any areas on which you're looking for more information as a charity trustee. They can also give specific guidance to charities in particular situations, although, as I've said, they're often reluctant to do so purely from a resource perspective. And looking at the powers that they have, I sort of briefly term these either the support powers that they have or the protective powers that they have in the sector. And its support powers are obviously the issuing of guidance that it does, the maintaining the register of charities, and the making of schemes and orders to allow charities to carry out particular activities where they can otherwise do so, or they need to make amendments to their governing instruments. The protective powers are there to protect the assets of the charitable sector, and that includes opening what we call statutory inquiries where they believe there's misconduct or mismanagement in the administration of a charity. And that is really where their powers as a regulator kick in, and they can disqualify trustees, appoint interim managers, issue official warnings, and direct that charitable property and resources are used in a particular way. And those have been enhanced recently in an act in 2016. You may be thinking, what are the sort of prompts for the Commission using its powers? Well, as it says on the slide, they may be where a complaint has been made by, sorry, I missed a page there. Maybe where a complaint is made by the general public, which happens quite often. It may be from media coverage, and the Charity Commission are always quite hot on making sure they can see what's in the media about what's going on in particular charities. Or it may be because a charity has reported something to the Charity Commission, as it is obliged to do, where a serious incident occurs within the charity. And I'm going to talk about that in a little bit more detail in a moment. So with all that in mind, we'll look a bit more about the roles and duties of trustees, but I think the best place to start is really going back to basics about what is a charity trustee. And charity law provides that a trustee is a person who has the general management and control of the administration of a charity. And that's a pretty good, accurate description of what charity trustees do, in that they're responsible for everything the charity does and how it meets its charitable objectives. And the Charity Commission's description, also quite helpful. In their views, trustees have and must accept responsibility for directing the affairs of a charity and ensuring to be solvent, well-run, and delivering the charitable outcomes for the benefit of the public for which it has been set up. And how must we as individuals carry out our role? Well, we must do so in exercising such care as is reasonable in the circumstances. And in doing so, you must use your own skills and experience in helping you do that. And this does mean that some trustees will be deemed to have a higher degree of skill, such as those with specific skills. And obviously the area to look at there is the context of lawyers on the boards of charities, where you will be deemed to have a higher degree of skill and understanding in respect of legal issues. It should be clear, however, that just because you have a particular skill as a lawyer, that doesn't mean you are required to give advice on all legal issues. You couldn't possibly do so. And as I said at the beginning, I've been a trustee of a number of charities, and I think as a lawyer on the board of a charity, your role is really to be spotting legal issues and helping a charity prioritise those areas where professional advice needs to be taken. As lawyers, there's probably a couple of other issues to bear in mind, which is if you are giving advice, whether you're doing so on your firm's behalf or in your own capacity, because although many of us believe we are fantastic lawyers, we're not normally prepared to do so, or we don't have the backing of our own firm's indemnity policy. And also where it is your firm that is giving advice to a charity which you're involved in, just thinking about the other issues that arise there in terms of trustee benefits and conflicts of interest. I'm going to talk about those a bit later on. So thinking a bit more in detail about what happens when it all goes wrong, which of course we absolutely hope it won't, and for the vast majority of charities it never does, but it's something that I think is worth covering at this point. If as a charity trustee you fail to act in accordance with your duties, your liability in a breach of trust situation is to put the charity back into the position it would have been in had the breach not occurred. And if your charity is incorporated, that will not be relevant in this context. Limited liability is about the liability the charity owed to a third party, but here we are talking about a liability that you owe to the trust yourself. It is a joint and severable liability that you owe as charity trustees, and this means that you must take responsibility for the actions of the board as a whole. And if you disagree with the decision that the board has taken, then you must voice your concern. And if you're particularly concerned about an area and you're not able to influence the board, in respect of that, then it is of course open for you to resign. But if a decision is taken and you decide to remain on the board, then it really is incumbent on you to stand behind the decision that's collectively made as a board. Now, the law does allow for charity trustees to be relieved of liability in certain circumstances, and the court or the commission, where they believe that a trustee has acted honestly and reasonably, then they can relieve you of liability, but that is certainly not something that any of you should be seeking to rely on. But most charities will have in place trustee indemnity insurance. As I say, that will be the vast majority of charities will have that in place. But of course, just remember that it isn't a reason to disregard your duties, because the insurance will only cover accidental breaches. It won't cover where you've acted dishonestly or recklessly in carrying out your duties. So let's now turn to look at duties and responsibilities in a bit more detail. What I say at this point is, if there's nothing else you remember from what I've got to say today, it's just to always go back to the fundamental duty that you owe as a charity trustee is to act in the best interest of the charity at all times. And we're going to look at 4 different aspects to that. So the duty to act within the objects and powers of the charity, the duty to act without unauthorised benefit, the duty to act without conflict of interest, and the duty to act personally. And this particular slide will come familiar to you as we go through, as we come back to thinking about how those duties sit with that fundamental duty. The charitable objects of your charity will be set out in the Constitution. The Constitution will depend on how your charity is structured. So if you're a company, it will be your Articles of Association. If you're a CIO, there's a CIO Constitution, maybe your trustee or charity commission scheme if you're unincorporated. You should be really mindful of what your objects are, because there may be that you're set up to advance a particular charitable purpose, but there may be restrictions in there about how you do so. That may be geographic restrictions in terms of the area of the country or within the UK that you operate, or it may be the type of beneficiaries that you are set up to assist. And being particularly mindful of what I term mission creep, and that's where the activities of a charity gradually change over time. It's often because charities are chasing different funding streams that require different things. So if you think about that in the context of a charity that is set up to support people who are blind or partially sighted, you can see how that would quickly become a charity that supports people who are blind or partially sighted, but also have other complex needs and disabilities. And the charity becomes really, really good at catering for people with those complex needs and disabilities. But over a period of time, the requirement to also be partially sighted or blind just falls away, and you creep further and further away from your charitable objects, which were to support the blind and partially sighted. So just being really clear about what is contained in your charitable objects, and ensuring that you don't suffer from mission creep. The other area in terms of sort of looking at purposes and objects is where you hold assets subject to a tighter restriction. So that may be because they are restricted assets or funds or permanent endowments. So if you hold a restricted asset, it's normally to be used for a particular narrower purpose of the charity. So if you're a charity set up to advance education and you fundraise for a new sports centre or theatre, and you hold assets that are raised in that way, then they must be used for that purpose and not the general objects of the charity. Permanent endowment is an asset that cannot be spent as if it were income, but instead it must be invested and the income used to further the purposes of the charity. So you must preserve the capital asset and the growth on that capital asset. Again, that's an area where we often see trustees fail to comply with their duties. So it's really about understanding what assets the charity has available to it, how it can use those, and whether that's more restrictive than the general purposes for which the charity is set up. So going back to those duties and responsibilities, the second one I want to talk about is the duty to act without unauthorised personal benefit. So it's one of the most overriding principles of being a charity trustee that you act voluntarily and gratuitously, and charity law prohibits the provision of benefits to a charity trustee without express authorisation in the governing instrument from the Charity Commission or by law. So that isn't to say that you cannot benefit in any circumstances, but it must be authorised, and you must be familiar with your constitution to know what is or it isn't covered. There are statutory provisions, but again, whether you can use them will depend on the constitution that you have. And just be mindful that if you do have an authorisation in your governing document, then it may set out certain procedures that you need to follow in order to take advantage of them. So just making sure you follow those procedures. So being aware that advice by your own firm is likely to fall within that category, particularly if you are a partner or otherwise share in the profits of a charity. Most governing documents will allow for a solicitor to provide advice to a charity of which he's a trustee, and that's been recognised for many, many years in governing documents, and it is provided for in statutes, albeit not all trustees can take advantage of those new statutory provisions. So it's just being clear about what it is and what it is not that you can do in relation to your charity. Right, moving on to talk about conflicts of interest. Trustees owe a fundamental duty to act at all times in the best interests of the charity. But where a personal interest that you may have, because you have a financial interest in a contract, or you have a conflict of duty, for example, where you owe a similar duty to another organisation, has the potential to conflict with that fundamental duty, then there will be a conflict of interest in place. So that's looking at conflicts of interest, which are normally financial interests, and conflicts of duty or loyalty, which are normally where you owe similar duties to another person or organisation. Now, the trustees' duties in relation to conflicts are really quite wide, and it applies where there is a conflict, but also where there may be a conflict. And conflicts arise for the vast majority of charities at one time or another, but it is something that the Commission regularly criticises charities for, as well as members of the public. I've just set out here a quote from the Charity Commission guidance, which says that conflicts of interest affect charities of all types and sizes. They can lead to decisions that are not in the best interest of the charity and which are invalid or open to challenge, and can also damage a charity's reputation. These harmful effects can be prevented where individual trustees can identify the conflicts. The trustee body can act to prevent them from affecting their decision making. Again, there may well be procedures in your governing document which sets out how conflicts of interest are to be dealt with. And the precise mechanism for doing that will again depend on how your charity is constituted. So for companies, it is a bit more complicated, and there's normally an authorisation procedure that needs to be gone through as well. And as I say, this is an area where we often see the Commission criticise charities. And I would say, as a practitioner, I think charities are generally much better now at spotting conflicts of interest that relate to financial benefits. But I think the area where it's severely lacking is in relation to conflicts of loyalty, and that's often where we see charities go wrong. So now touching on the duty to act personally. Governance is mainly a non-executive role in which trustees serve part-time and in a voluntary capacity. The responsibilities and duties of being a trustee are personal to you. But for many charities, of course, the trustees cannot, of course, carry out all of the activities and roles of the charity and must be able to delegate to others to assist them in carrying that out. And there are two key forms of that, which I'm sure you'll be familiar with. One is to subcommittees of the board, and others is to executives or employees of the charity who carry out particular aspects of work. But what is important for trustees to remember is that where you delegate, it does involve a duty to supervise any of those individuals and to hold them to account. I would always recommend that there are clear terms of reference in place for committees and to executives to know where everybody stands and to ensure that they know what they can and can't be doing and how they're going to be held to account. So one of the key things to bear in mind there is if you have a committee of the board, those can act in two very different capacities. You can have a committee which is purely advisory and it considers matters and makes recommendations to the board at the next governing body meeting or trustee body meeting, or you could have a committee that is authorised to make decisions that bind the board. And those are two very different roles, and unless you have clear terms of reference, it isn't clear which of those will apply. So, mitigating the risk of personal liability. How can we as charities ensure that our trustees are acting in accordance with their duties for the benefit of the charity and avoiding any of those potential liabilities? Well, a good understanding of the legal and regulatory framework is obviously key to that. And for most trustees, attending training is really vital to ensure that they understand the roles and duties that they have. But also ensuring that they understand the charity itself, the structures it has, what it's set up to do, are also as important. And also looking at good decision making. And I'm just going to look at decision making briefly. I would say here that the Commission's guidance on decision making I think is particularly good. That's CC 27 for anybody that wants to look it up. And why is decision making, good decision making important? It helps the trustees act in accordance with their duties. It mitigates that risk of any invalid decisions or legal challenges. It avoids the risk of loss or damage to the charity or its assets or reputation by making bad decisions, and again, it avoids those risks of personal liabilities. The Commission says in CC 27 it recognises that charities are independent. The trustees are responsible for governing the charity and making the decisions about how it should be run. Making decisions is one of the most important parts of being a trustee. Some decisions are simple and straightforward, and others are complex or far-reaching in their consequences. And that's particularly true for charities over the last few months. So the Commission's approach is that trustees should make decisions that are within the range of decisions that a reasonable trustee body could make. It is not for the Commission, or indeed the Court, to determine what was the right decision or even the best decision. It's just about whether trustees took a decision within the realms of that what a reasonable body of trustees can make. But what I think is really important is that trustees have the confidence to be able to make decisions, understand their duties, and have the information they need in order to be able to make those decisions. And a lot of the decision-making process is about ensuring that you do have the information you need. You're taking into account all of the relevant factors in making that decision and ignoring those that aren't relevant. Just to touch on some key governance areas here, let's just touch on accountability to start with. There are a number of ways in which trustees are accountable for the decisions that they make. First of those is obviously the annual report and financial statements that all charities are required to make and are filed at the Charity Commission and, where relevant, also Companies House. And no doubt you'll be familiar with the statement of recommended practice that charities need to follow in order to do those. So that's a key way in which charities are held to account, because those accounts are open for all to see if they wish to do so. Also, we mentioned at the beginning, we were talking about how the Commission become aware of issues as serious incident reporting. Trustees have a duty to report to the Charity Commission any incident which results in or risks significant loss to a charity's money, assets, or damage to a charity's property, or harm to its work, beneficiaries or reputation. And that's quite a wide duty that trustees have there, and they are required each year in their annual report to the Commission to confirm whether any situations have arisen that they haven't reported. And of course, it is an offence to provide false or misleading information to the Charity Commission. So it's quite an important one. And again, that is an area of guidance which I would really recommend charities and trustees are aware of, and then also an area where the Commission has become much more hot on criticising charities that haven't reported serious incidents to them. There are other couple of areas around charitable property that it's worth mentioning. Charity law sees property, real property, land and buildings, as being one of the key assets that a charity can have, and has particular protections around how they can be used. So where a charity seeks to sell land or otherwise dispose of property, like granting a lease, then there are particular procedures that they must go through, and those are around effectively getting advice from a surveyor to make sure that the best value is obtained for the sale of that property. Similarly, when you borrow money and it's secured over property, there is also a danger that the property could leak out of the charitable sector. So there are again requirements there around making sure that trustees go through certain procedures and take the relevant advice they need to before doing that. I should say, in the context of bank borrowing, that banks are normally not aware of that, and they may provide you with draft minutes and other documents that don't reflect the duties and responsibilities that you have, so just be alive to that one. There may be other ways that your charity is accountable. It may have funding agreements with other bodies that require it to report back, or you may hold general meetings of members and so forth, where you're required to report to them about the role of the charity and the work that's carried out. I'm going to touch briefly on risk areas. I know this is something that Caroline, I think is going to mention briefly as well. In my view, risk can be broadly separated into two areas: the operational risks that a charity faces and the financial risks that a charity faces. And often where there are risks that come to fruition, it is because of the result of poor governance, either in the strategic planning process, looking at the business and operating model, the relationship between the trustees and the executives, or the management information that trustees have available to them in making decisions. Or sometimes it can be completely out of their control. We've all just currently living through a situation which no board of trustees could really have foreseen, and that obviously has had a huge impact on a lot of charities. On this slide, I've set out some of the key operational risks that we see as a firm when advising charities. So sadly, governance disputes are all too common, as are a failure to comply with legal and regulatory requirements, and I've set out a few there. One that's worth mentioning is safeguarding. Most are familiar with safeguarding in the context of charities or organisations that work with children or vulnerable adults, but charities have a duty to safeguard everybody that comes into contact with the charity, and to protect them from harm. So the safeguarding duties that a charity has are much wider than those of any other organisation. Unmanaged conflicts of interest and benefits for trustees is something we talked about earlier, and again that is something that we increasingly see as an operational risk to charities. Financial risks, of course, over-reliance on single sources of income, really easy to say, but that should be sorted out, very difficult to do in practice. There are some charities that have disproportionate levels of restricted funds. We mentioned restricted funds earlier, where they can only be used for a particular purpose. And sometimes where you have too many for too many disparate purposes, it can make the charity very difficult to manage. Too few reserves is another key issue. We'll all remember the case of the kids company fiasco, where that went bust because it didn't have the reserves that it should have done in place, and the Commission took a few measures with checking charities had the reserves they needed and asking questions about that at the time. Defective financial risk management, so that's really looking at financial processes and procedures to avoid things like fraud, which charities sadly are very vulnerable to. And obviously there are the obvious risks of insolvency, and that can be because, well, the obvious tier tests for insolvency around the cash flow test and the asset test, but also just thinking about restricted funds in that context can make solvency a difficult thing to measure for some charities, and being aware that where there is a risk of insolvency, the duties of trustees can change depending on how the charity is constituted under insolvency legislation. And then briefly looking at risk management. Why is that important? Well, once a risk has been identified, it is really important to manage that risk, mitigate it. But it's also important in relation to just general decision making, strategic planning, and again having that confidence as a board of trustees to make the decisions that you need to make. And generally looking at risk management is about assessing risk. For most charities that will be about identifying the key risks that you may be subject to, looking at the severity of those and the impact and likelihood of occurrence, and using that in order to populate a risk register. And I've just put up here some of the Commission's guidance on risk mitigation. And there are ideas behind it, which, again, some of these areas are easy to say, not so easy to do in practice. But their view on risk is where the risk is too high, then a charity may want to stop the activity altogether. It may want to transfer the risk. That might be to a wholly owned trading subsidiary where the risk's financial at least or ring-fenced within it, or contracting it out to another third party. It may just be a case of having to manage the risks by looking at the reserves and financial controls that you have in place, or phasing in an activity, or looking at the insurance that you've got available. Or it may be simply accepting that some activities that charities carry out are inherently risky and they just need to be kept under careful review. Well, I hope that was helpful for everybody. I'm now going to hand over to Caroline, who's going to talk some more about some of the practicalities of decision making in a COVID world. Thank you very much.
Thank you so much, Emma-Jane. That was fascinating, actually, and really, really helpful and important for trustees to be able to have those things to their hand. So I'm Caroline Turner-Inskip, and I'm a partner at Simmons Simmons, but I'm a trustee of the Sofa Project, which was named after the acronym Shift Old Furniture Around. As its objects and its charitable aims, it's the supporting of rehabilitation of prisoners through work opportunities within the organisation, and those opportunities and activities mainly comprise of reuse of unwanted donated furniture, domestic appliances, refurbishment of them and the skill sets that come with that, and then supplying them at low prices to people on low incomes. I became a trustee having supported the Sofa Project as a real estate lawyer for granting of a new lease for them on the Gloucester Road in Bristol, as they were looking to try and expand their ability to supply the works that are being held for them out of shops around the Bristol area, and was then asked to join them as a trustee. The main and most interesting thing for me was as we started and as I started to learn what the trustees were doing was the extent to which they are required, and we are required to do all the things that Emma-Jane has just touched upon as being key to the running of the Sofa Project. And that generally pre-COVID was 4 meetings per year that would follow a pretty set format, looking at management accounts, considering the financial status of the charity, considering our fundraising strategy and grant strategy and discussing best ways forward with that, health and safety, and looking at key risk assessments that needed to be carried out as part of the works that were being carried out, and indeed how those risk assessments then played into the charitable objects, but also into some of the partnership arrangements that were in place, for example with the reuse network that we are part of. The meeting would always have the CEO's report for us to be able to consider her views of how the charity were progressing and any particular support she needed, and then of course in particular looking at the prisoner network and how that was interplaying with the charity, but also employees themselves and what was needed there, and then March arrived, and I don't need to tell anybody what happened at the beginning of the year to now find ourselves in a different position as trustees. And we very rapidly had to find ourselves being slightly more fleet of foot than perhaps had previously been either necessary or indeed possible, with extraordinary meetings being called to ensure that we were supporting the charity and the CEO in delivery of the charity's objects, and it required some fairly rapid thinking around what the ever-changing COVID legislation was doing to the charity, its impacts, the potential to need to call for additional grant funding that we perhaps in other circumstances might not have called out for, and indeed at its very basics making sure that the necessary PPE was available to be able to manage and continue working through the charity. Also some incredibly difficult decisions that have to be made as a trustee in support of the charity and the CEO around the future survival and the financial health of the charity to ensure that we were in compliance with what we were doing. On top of course, suddenly having to do our trustee meetings through the wonderful world that is Zoom. And so it really shifted and changed our response, and it for me was fascinating to see how rapidly and how dynamic the trustee group could become in a more challenged environment, and being able to move that forward. But I think for me, Emma-Jane, that really is a sort of high level summary of the things that on a day-to-day basis have to be in our mind as trustees, and the steps that we had to take, particularly through COVID, but also more generally as part of our duties on a day-to-day basis and as part of the general arrangements. I don't know, Emma-Jane, from your perspective, obviously seeing and identifying and working on some of the risks, whether or not you've seen a particular change in how trustees are having to respond, or what those look like for you.
I think certainly as an advisor to charities, you've seen trustees need to make decisions rather quicker, and by, as you say, a different format to that they are used to over some kind of video conferencing. And as I say, there have been some very difficult decisions which trustees have had to make, and often you'll see with boards of trustees that something comes up at a trustees meeting, and it's considered, and it's sort of passed over to the next meeting where it's picked up again, and you finally make a decision. Well, that, you know, in a COVID world, that just isn't possible anymore. Decisions have been for all types of business, but charities as well have had to be made quickly, and they've had to do things and change things. And for some, you know, it's actually seen them able to push forward things and make decisions that needed to be made anyway. So that's been interesting to see. But certainly, I'd see quicker decisions have need to be made, and looking at governance processes, and sometimes just having to readdress what that looks like in terms of how the process of decision making in a COVID world, certainly.
Peter, I think probably over to you. Any questions that have come up through the session, or anything that's come out from that's worth chatting through?
Thank you both. Anyway, that was really, really interesting. I found it very helpful for me personally in some of the things that I'm doing. We haven't actually got any questions yet, and I can see on our screen. So please let us have some questions. And while you're thinking about that, I just wanted to echo some of Caroline's comments actually about the challenges which hit us and have continued since March, because I'm in fact I'm not a trustee as such. I'm a non-exec director of a trading subsidiary of Avon Wildlife Trust, which is a charity. So that's one of these sort of organisations or arrangements that Emma-Jane was talking about, and the particular trading body that I'm a non-exec director for is called Folly Farm, which some of you may know. And Folly Farm, a fantastic set of buildings, but it's used partly for educational purposes, but it's also, and its primary source of income is as a wedding venue. and also for conferences and other meetings for other organisations. So it won't take you long to guess some of the challenges that we have faced. So from being a body of, let's call them trustees for this purpose, who would meet quarterly and do things on a fairly sort of steady basis, we've suddenly had to go into overdrive, and we meet by Zoom once a month, and actually there are communications in between meetings as needed, because the staff need a lot of support, and we've been out without income but been making grant applications. And the one thing that has impressed me enormously is the way that the team on the ground have been dealing with it. They've been fantastically resourceful in addressing these issues, and also the trustee group really got together to support what I call the executive team, making decisions quickly, sensibly, and I think it sort of brought us all together in a way which we hadn't quite anticipated, shall we say. But real challenges, and actually trustees can do a fantastically useful job if they are prepared to get stuck in that way. So that's my personal experience. I can see we've got a couple of questions. So one's for one's specifically Caroline, and one's for all. And it's one of our previous contributors. That's great. Thanks for coming back again. So the first one, Caroline, in terms of the issues that Emma-Jane touched upon, what are the most challenging issues that you have had to deal with? And I'm assuming that's in your professional capacity as a lawyer and partner at VWV. So Caroline, how about that one?
I think for me, the real key when I'm looking specifically, I suppose, is from a trustee perspective, and more recently, and this comes on, I suppose, to the second question of has sort of COVID made it worse, is that the decision making has been far more challenging, and in very difficult times, the same kind of decisions that businesses are having to make that as a charity you never want to find yourself having to make. Decisions around having to protect and look after the charity and its long-term aims. So certainly decision making around the employees. Also, one of the key objects of SOFA in particular is about prisoner rehabilitation. Actually, very sort of expectedly, as part of the COVID pandemic, we've not been able to have prisoners come in as part of the process that we've had, and the need to be very cautious and to really consider the risk assessments, what those look like, and how we make sure everyone is safe, as well as still being able to continue with the SOFA project and what's needed. So certainly those for me have been the things more recently that have certainly been there. I have to also say the financial health of a charity, all the points that Emma-Jane you mentioned about reserves and ensuring solvency. I think if for any charity, it's a daily conversation to ensure that you're managing effectively and carefully how the solvency and the management of the finances of the charity, and those are really hard conversations to be having sometimes in that side. I don't know, Emma-Jane, similarly from your perspective.
Yeah, I just think there is a worse time to be a trustee than any other. In a way, it comes back to your motivations behind being a trustee. I always say to people I work with, if you're going to be a trustee of a charity, then make sure it is one you believe in its purposes, and you want to make a difference, not just because someone's asked you to be a trustee on it or whatever. Because is it a worse time to be a trustee? Well, no, because those causes need somebody who is going to make the right decisions for them more than ever. And if your motivation behind being a trustee is because you want the experience that it gives you, which is absolutely, I think, a valid reason for doing it, it can give some wonderful opportunities to people to be involved in decision making while supporting a charitable purpose. Then there are opportunities, huge opportunities out there to be involved in making some absolutely key decisions in the sector at the moment, because almost without exception, charities, whatever they do, are have some key decisions to make over the next few months if they've not made them already. And that is something fantastically rewarding to be involved in. So that would sort of go back to that for me. But again, it just comes back to, you know, is it a bad time? Well, if you understand what your duties and responsibilities are, then it's no worse than any other time, because those duties and responsibilities will always apply.
Thanks, Emma-Jane. In fact, I was going to endorse that. I think it's an interesting way of putting the question, whether it's worse time or better time. I think actually it's an incredibly important time for people to be doing trustee roles and taking them responsibly. And what I would say, and this doesn't apply just to the subject we're talking about today, but if you've gone through a difficult period, and whatever it happens to be, and I've been managing law firms for a number of years, if you go through difficult times, you actually learn a heck of a lot through that. That in itself can be pretty rewarding. So I think it's good for trustees as individuals, but also incredibly helpful for the charities for which they are providing trustee services. That you know, they're going through this together.
I was going to actually ask that and flip it around in that, do you think actually this is the best time to be a trustee? Because nobody likes a committee that goes nowhere and you end up having the same meetings time and time again every quarter. I mean, is it actually the reverse, and that you actually feel that you're really contributing when everybody's focused on the task at hand and action points get actioned?
I would definitely say that. I think that the dynamic has shifted, and the ability to move things forward, actually being able to do things as a video conference in this kind of way, has allowed conversations to happen. I think also there have been things that have not really been COVID related, but actually because of some of the triggers that COVID have created, matters have moved forward, and we've been able to make decisions that have I suppose there's been a catalyst, but they've always been points that probably needed to be decided on anyway. So yeah, no, I agree with you, Vic. It's a time where you can really start to drive through a difference, and make things far more proactive perhaps than in other times.
I think that's it for questions. If there's anybody who would like to ask another question, because I think we're a few minutes away from 2 o'clock anyway, but this is your opportunity. And whilst, I think one's popped up. Right, John, do you believe there is enough practical support and guidance provided by the Charity Commission for trustees, or do they need to rely on existing trustees to guide them? I suppose that's first a question for you, Emma-Jane, and then possibly Caroline could comment in practice, you know, what support she felt she got from the Charity Commission guidance.
Well, certainly the Charity Commission does provide a lot of advice documents, so on a whole wealth of different topics. What I think the Commission struggles with, and there is no solution to this, is the charitable sector is so diverse. So if you take the guidance on reporting serious incidents, for example, what would be a serious incident for one charity is not a serious incident for another. The type of serious incidents that might arise in a charity that's dealing with very vulnerable beneficiaries are very different to the sort of serious incidents that might occur within a grant-giving charity, for example. And somehow or other, the Charity Commission needs to pull all that together and provide some guidance that's a sort of tries to fit all charities. And it's a case of I would say this, wouldn't I? But it is absolutely right that some charities, in fact, most charities, will need to take professional advice on some areas, because the guidance that you have from the Charity Commission isn't going to be enough to see you through a particular scenario as it happens. And that's absolutely right and proper, and absolutely right and proper for the charity to use its charitable assets to pay for that advice. Whether you can rely on the existing board of trustees, I think that there is a lot to be learned from trustees that have been on a board for some time, because they will understand how the charity operates in a way that, as a new trustee, it's very difficult to understand. But on the other side of the coin, I would say that charities do need new trustees from time to time to bring fresh perspective, different ideas onto the board, and it's important to have that. So all boards of trustees should be looking at the skills and experience that they have on the board at any particular time, and the need to bring fresh people on for that new perspective, while balancing that with people who've been there for some time, to bring the sort of historical perspective to that. So in answer to the question, can the Commission give you everything you need? Absolutely not. It can't do that. And even in individual scenarios, it just doesn't have the capacity to give every charity the advice that it needs when it wants it. Can you learn a lot from existing trustees? Absolutely yes, but not everything.
Thanks, Emma-Jane. We're nearly out of time, but Caroline, have you got any final comments you would like to make in relation to that question?
I think the main thing for me is that in order to be able to comply with your duties as a trustee, you need to understand the charity that you're supporting. And therefore, whilst absolutely I agree, Emma-Jane, that the Charity Commission has lots of the papers and the detail and the facts of your obligations, the only way that you comply with your duties is by understanding what that charity needs and what its aims are and how it needs to be run. And so for me, the Board of Trustees were invaluable in my first sort of 6 months to learn, but also, do you know what, the CEO herself, understanding the challenges that she was facing, what the charity was needing, and ensuring that there's that interface between the two and that they're not just two siloed elements. The charity itself and the trustees have to interact together and act as one in line with its duties themselves.
That's great. Thanks, Caroline. I've got lots of questions myself, actually, but we've run out of time. So, so can I just say a big thank you to our contributors, and to Emma-Jane and Caroline in particular. And thanks to the Bristol Trustee Group and Victoria for organising this particular webinar, and also to Bristol Law Society, who kindly hosted this session. And thanks to all of you for joining us, and hope you'll join us again in the near future. Thank you very much indeed. Bye.
Thanks. Bye.